The injury lawyer, Karl Truman, is here with us every Tuesday, opening up the WBKI legal line. I'm Craig Hoffman. Tara Bassett is here, our guest co-host. And Karl, how are you doing, Karl?
Morning. When Craig asked you your favorite TV show on CW, you're supposed to have said The Legal Line.
Absolutely. How foolish of me.
Well, she did say, I was asking her favorite CW show, but she was Louisville this morning.
I do.
Hey, have you been involved in an accident, maybe a bicycle, a car, a wreck, and you don't know what to do? Maybe you're not getting enough information. What about a disability claim, Social Security disability, or workers' comp? Call us right now.
Yes.
502-276-2118. This is your opportunity to talk to Karl Truman, the injury lawyer. So Tara is our guest, and she has a Social Security disability question.
I wanted to ask you a question about this, Karl, because
Sure.
I have friends who have dealt with this before. They've been, very badly injured in an accident, or they've had a physical disability. What actually constitutes what you'd consider a viable claim for disability? Do you have to be dying, or do you have to be so sick that you can't work at all?
Well, that's a great question. I get a lot, especially in today's economy with people being laid off and losing their job. A lot of times people will call and say, well, I can't do my job anymore, I want disability. Well, and I have to explain to them that it's not enough just to say, well, I can't do my job that I was doing. You have to basically show you can't do any type of gainful employment. And there's a lot of factors that go into it. Age, education, work history, what your physical limitations are.
Sure.
So there's more to it than just what job you can do, because, for example, a younger person with the same disability may not qualify as if they were an older person with that same disability. So that's why you've really got to look at the age, and someone that has a college degree may be more employable for less strenuous work than someone that has a GED or no education at all.
And it's for a period of time, right?
No.
Well, you have to establish for a period of 12 months.
Okay.
So if it's, if you cannot work for 6 months and you're disabled, and then you can go back to work within 12 months, then no, you're not eligible for Social Security disability.
Karl Truman is here. We're opening up the legal line, 502-276-2118. Don't be shy. Give us a call. He will answer your legal questions. And we take emails, too, live at WBKI.tv. We got one from Terry in Spencer County for the injury lawyer, Karl Truman, here on Louisville Live this morning. I've been following the immigration debate for some time. When they're in this country illegally and commit a crime, or there is a civil lawsuit against them, how does the victim collect damages? Interesting question.
Yeah.
Spencer County, my hometown.
Okay.
Well, that's a tough question. If they don't have any assets, and it's true whether they're here legally or illegally.
Yes.
I mean, there's plenty of situations where, I've had clients hit by someone who had no insurance, and then my clients will say, well, can't we go after them personally? Yes, you can, but if you get a judgment, is it worth the paper it's written on if you can't collect it or they file bankruptcy? So, certainly being illegal and not having any way to collect, certainly that does make it more complicated. But, it's not a question of are they here illegally or legally. It's a question of do they have insurance, do they have assets, do they have an ability to pay? Because, I see it just as often with people here, born and raised here, that have no insurance and no assets, and that's why it's you have to protect yourself.
Absolutely.
For particularly with an automobile accident situation, you want to make sure that you have uninsured and underinsured motorist coverage, and that's very important. I talk about that a lot because I see it so often where clients have severe injuries and they're hit by someone that didn't have any insurance.
Yes.
So on your own policy, you have to have uninsured motorist coverage, which covers you in case someone hits you and they don't have any insurance, because you're protecting yourself.
We're taking your phone calls, 502-276-2118. You can always go to Karl's website or call him at 1-800-ACCIDENT after the show's over. But we got a call from Sherry in Shelbyville. Good morning, Sherry. What is your question for Karl Truman?
Yeah, my husband was hurt last year, and he had his surgery and was released from the doctor on July 12th. They cut our check. My husband's still in pain management. Is that legal for them just to cut our check like that?
I'm really having trouble.
Okay,
hearing
so
with
say
the
that again.
sound in the
Say that again,
call.
Sherry. You were in the hospital, and how did this all develop?
It was a work injury.
Work injury.
A work injury. He was released July 9th from the doctor on 4 hours sit-down duty, and he's still in pain management, and they cut our check. Is there any way we can fix that to where people won't have to
Okay.
sell everything they own and do without?
I think I understand the question, and let me try to answer it by explaining the way the workers' compensation law is supposed to work. So, I believe it was her husband was hurt on the job, and I assume it was in Kentucky, because the laws are different between Kentucky and Indiana. But once you're hurt on the job, the employer, of course, is supposed to provide all your medical care. And one of the benefits of Kentucky workers' comp law is that you get to select your treating doctor. While the doctor has you off work, that's called temporary total disability, where you're not able to work at all. The company, the employer, is required to pay 66 2/3% of your average weekly wage. And then they pay that until the doctor releases you to go back to work, which, he may release them to go back with restrictions or not with restrictions. If the doctor releases you to go back with restrictions and the employer cannot accommodate those restrictions, then you're still temporarily disabled, so they should still pay those benefits.
Sherry, what I would recommend that you do, if you need more information, don't be shy. Call Karl Truman at 1-800-ACCIDENT or go to his website. It's confidential. If you do need some assistance, they'll put you in the right direction. But we are taking your phone calls, 502-276-2118, and your emails, live at WBKI.TV.
And we have another email, and it's a similar type of question, Carl. It says, I was hurt on a job about 6 months ago when a piece of lumber fell from the 3rd floor of a home and hit my leg. I filed a workers' comp claim, and my employer said everything would be fine. I filed all the necessary papers. My employer told me a few weeks ago the injury might not be covered because I was not following work safety procedures. That is not true, and I have witnesses. However, this is where the rub is. The foreman is a relative of my employer, and I'm not sure what to do. That's from Harold in Louisville. What a conundrum.
Well, Harold certainly needs an experienced workers' compensation attorney to help him with that, because what they're saying is not true. They can't just stop your benefits or say, we're not going to pay you because of some safety violation. Now, there are procedures that they can reduce your benefits or reduce your settlement if you violated a known safety procedure. But generally speaking, it has to be a written safety procedure. For example, if there's a written policy that says everyone must wear a hard hat on the work site and you're not wearing it and you get hit in the head, but that doesn't mean they're not responsible to pay you anything. It means that they could get a discount or cut your benefits, for your settlement. So it's not that cut and dry to just say, well, we think you weren't safe. That doesn't prevent benefits.
Well, of course, you can call 1-800-ACCIDENT. Real quickly before we run out of time, pets. Tara likes pets. You have a pet question yourself for Carl.
I do, and I'm thinking I don't get free legal advice that often, so let me just ask you. 3 dogs I have. Everybody I know owns dogs. What if a dog just loses its cool and bites somebody on my property? It's my responsibility, obviously. Does my homeowners cover that? And what happens if my dog bites somebody out in public and not on my property?
Well, and that's always a concern of mine, because I go jogging a lot, and I'm always encountering dogs and on the street. And when you ask about being on your property, it kind of depends. Why is that person on your property? Were they invited on your property? Or are they trespassing on your property? Is the dog just on your property? That could be a little bit different, depending, again, why they're on your property. But, generally speaking, your homeowner's insurance coverage would cover if there is a claim for a dog bite. If your dog leaves your property, if I'm out in the street jogging by and your dog comes chasing after me and bites me, then, yeah, you're going to be responsible.
Then I'm in a little trouble. Now, just as a caveat, my dogs have never bitten anyone, and they'll mostly lick you to death. Even the 100-pound one will lick you to death.
Well, believe it or not, the only time that I have been bitten out jogging is by a small dog.
Absolutely.
Has not been a big dog.
Ferocious beast or everything. But hey, you see the number right
Killer
there.
rabbit.
1-800-ACCIDENT. Go to TrumanLaw.com and feel free to call his office. Carl practices law in Kentucky and Indiana, services all of Kentucky and Indiana. So give him a call. It's confidential, and he'll try to get you in the right direction, as we say. But Carl, always a pleasure to have you with us.
Thanks. Great to be back.
Great answers. Thank you.
We'll be back with more here on Louisville Live this morning. We'll give away those tickets to the Broadway Across America to Stomp and Dress for Success. Don't go away.